5 seconds. Start. Mr. Ranjit Kumar, learned senior counsel for the appellants, argued that the information or complaint submitted by Ram Saini and by Vijay Kumar Agrawal does not make out a cognizable offence for enabling the court to direct for the registration of the FIR. The High Court could not have directed for the registration of the FIR as the procedure laid down by the various decisions of this court was not followed before approaching the High Court. Secondly, the High Court could not have recorded a finding of commission of a cognizable offence which leaves nothing for the investigating officer to opine on after the completion of the investigation except to submit a charge sheet. He further argued that in the so-called preliminary inquiry conducted by the Joint Director CBI, it has been reported that no cognizable offence is made out for the purpose of investigation. Therefore, it was not open for the High Court to have substituted its own finding and to direct for the registration of the FIR. He emphasized that even if for the sake of argument it is accepted that a case for investigation is made out against Vinod Kumar Pandey, there is no averment or iota of material to rope in Neeraj Kumar, the other officer. A further submission has been made by Mr. Ranjit Kumar, learned senior counsel for the appellants, that the High Court manifestly erred in directing the investigation to be conducted by the special cell of the Delhi Police, which ordinarily investigates the matters relating to terrorism. The High Court also committed an error in directing the exclusion of preliminary inquiry report dated 26/4/2005 of the Joint Director CBI from consideration during the investigation. Mr. Raju, learned additional Solicitor General for the respondents, pressed an application for the impleadment of the CBI contending that as the preliminary inquiry was conducted by an officer of the CBI and the case involves allegations against the officers of the CBI. Therefore, the CBI is a proper party so as to defend the inquiry report and its officers. On merits, he submitted that the complaints do not make out any cognizable offence and are barred by Section 197 CRPC as whatever acts have been performed by the officers, they were in discharge of their official duties. The complaints are also hit by Section 140 of the Delhi Police Act 1978 are barred by limitation. Admittedly, the CBI was a party in the writ petitions before the High Court and had not chosen to assail the impugned orders, meaning thereby that the CBI never felt aggrieved by the said orders. The CBI, even if pleaded, would as the respondent or a pro forma respondent. It is well recognized in law that a respondent or a pro forma respondent may support the judgment impugned but cannot assail the same in his capacity as a respondent. The CBI has not independently challenged the aforesaid orders of the High Court. Moreover, the CBI is not the party actually aggrieved by the direction given by the High Court for the registration of the FIR against the two officers. Stop.